Visit us at GulfstreamMotorsports.com.
From the Sunshine State, this is Tampa Bay's 10 Talk.
It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
Good evening. It is Tuesday evening at 5 o'clock, and that means you are here listening to FLA Law on the radio. This is Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm in Tampa Bay, and the proud host and sponsors of FLA Law on the radio. This is a live call-in show, so feel free to give us a call at 727-441-3000. As I said, we are the oldest personal injury law firm in Tampa Bay. We are celebrating our 70th birthday this year. So we have been helping people after car accidents, work accidents, trip and falls, and Social Security disability claims since 1955. So please feel free to give us a call if you have any questions regarding those areas of law. But I am not alone this hour. I have a colleague with me, and Adam is here. Adam Rawman is here to answer questions regarding his areas of law. So, Adam, thank you for coming.
I appreciate the invitation. Thank you for asking.
Sure. Why don't you tell our listeners a little bit about you and what areas of law that you're here to help them with?
Sure. I own a preservation law firm. We do wills, trust, estate, probate, business law, and we do some real estate as well.
And I understand you're an FSU grad and then a Stetson grad as well.
Both Stetson and FSU, yes. So go Noles.
I was a USF and Stetson. So, but before you were a lawyer, you had a whole different career, didn't you?
I spent 15 years as a financial advisor. So I had a Series 7, Series 63, Series 65 life, health, and annuity license. And the Federal Securities Agency felt that I was more dangerous not selling securities and keeping a license than I would be if I was selling and had one. Okay. So I had to give that one up. But I still have the life, health, and annuity license, so I just refused to let it go, and I do the continuing education every year.
Oh, that's wonderful. And your practice is specializing in estate planning, probate, and even business law, right?
Yes.
And where is your practice at?
We just opened a new office, 1920 East Bay Drive in Largo.
And we were talking about just before we got on air, how crazy opening a new office is all about.
It's insane. There's a lot that goes into it that you don't even think about. It's one thing to sit there and practice law. It's another thing to open a law firm, run a law firm, and practice law.
Yeah. And so you've been working 7 days a week since I think you said December, right?
Since December, yep. Just trying to get things ready to move. We closed down one law firm and had to move a bunch of files, trying to get into a new building, which is the 1920 building, and get everything up and running from there.
That's perfect. And so this isn't your first go round of the law, though. I know you had 15 years as financial planner, but you also worked for another firm in estate planning, right? So
I've been an estate planning attorney for the last 14 years. Yeah. And for the last almost 11 years, I worked for a law firm called O'Connor Law Firm. So that was over on Belcher, and I spent about 10, 11 years there doing wills, trust, estate, probate, business law, everything that I'm doing now. And I also was doing that prior to joining Pat over at O'Connor Law Firm.
Wow. So listeners, he is here. He is quite knowledgeable on the estate planning, probate, and business law. He even throw a little financial advising in there as well. My dad was a financial advisor when he was alive. And in fact, he shared space with Joe Pippin.
Oh, did he?
Many, many decades ago. And so I understand the importance of financial advising. Now, it doesn't really play a big role in personal injury law, a little bit, but not a big role. But I can imagine your background in financial advising really plays a significant role in your role as an attorney in estate planning. Is that right?
It's the main reason I decided to do estate planning. When you're a financial advisor, you're helping people plan their future financially, try to make as much money as you can so they can have a retirement. The estate planning on the legal side, you're protecting them both while they're alive through the power of attorney, the healthcare surrogate, and the living will. And then you're making sure that their assets get transferred when they pass away. Although I like probate and I practice probate, if you come in to see me, I'm trying to help you avoid probate because probate can be an expensive process.
That's what I wanted to talk about. We're going to get to that as well, because I think that's what a lot of people don't fully appreciate. And so I think this next hour, I think we're going to be able to really educate some of our listeners about probate and avoiding probate and such like that. So if anybody has any questions, please feel free to give us a call at 727-441-3000. I did forget to mention that we are also live on Facebook on our firm's Facebook page at Perenich, Caulfield, Avril Noyes Injury Lawyers. So watch us live on Facebook. We are also on YouTube. But if you have a question and you don't feel like having your voice on the radio, just type in your question right in the comments on our Facebook page, and we'll be happy to address those questions as well. So before we take any calls, your firm name is Preservation Law Firm.
Yes, we help people preserve their legacy.
I was going to say, why did you choose that name?
It took a lot of thought. We went through a lot of different names that we could have had. I decided Preservation Law Firm because that's exactly what I'm doing. I'm preserving your legacy both while you're alive and when you pass away.
I think that's wonderful. I think it really gives your clients an idea of what your goal is. So that's wonderful. And one of the things you do is estate planning.
Yes.
And preserving the legacy through estate planning. Can you tell our listeners, what does estate planning encompass? And when should somebody really start doing their estate planning?
So everybody who's 18 years or older needs to have a will, power of attorney, healthcare surrogate, and a living will. The will is not as important for an 18-year-old as the other documents. The power of attorney, the healthcare surrogate, and the living will. Those are living documents because they're only valid while you're alive. The power of attorney allows somebody to act legally and financially for you.
Why can't their parents just do that?
Well, as soon as you turn 18, you lose the ability to do that. So any parent who has driven their kid to the first day of college and gone through that initial introduction into college finds out that they can't access the child's finances. They don't get to find out what the kids are doing for grades. They don't get anything. They're footing the bill, but they don't get any information. You also can't access your kids' bank accounts anymore unless your name is on the account. So having a power of attorney allows you to get some of that additional information. It gives you some authority with school. So if there is some issue in trying to find out, was the bill paid? Was there a problem with the bill? How can I get it paid? The power of attorney can help you get that done.
As a parent of a 19-year-old son, I have gone through that and I've lived that. And so I appreciate the importance of such a document and the inability to get the information that you otherwise could have gotten 6 months earlier.
And you're like, but I'm paying the bill. Why can't I get the
Exactly.
information? They're like, no, you can't get it. It's not yours.
So that's the, what about the medical authorization?
The healthcare surrogate is another one of the documents, and that allows somebody to make healthcare decisions when you can't communicate. So if your child were to get injured and we're under anesthesia, and what's different about the power of attorney and the healthcare surrogate, the power of attorney is valid as soon as you sign it, but you have to physically hand the document over in order for somebody to use it. The healthcare surrogate comes and goes in power. So if you're able to make your own decisions, you're making your own decisions. They put you under anesthesia for an hour, then you can't make a decision, and they contact the healthcare surrogate if they need to make a different decision. For example, if you went in for a surgery, maybe you were having kidney stones removed, and they put you under anesthesia and they find out that you have a hernia and they want to do hernia surgery. They can contact the healthcare surrogate who can authorize the surgery, leave you under anesthesia, let the second surgery take place, and you come out, everything was done instead of putting you under anesthesia 2 different times.
That's a perfect example. That's why that document seems so important.
It is. And then the third living document is your living will. And your living will only applies in 3 circumstances: a terminal condition, an end stage condition, or a persistent vegetative state. Terminal condition is disease-based. End stage condition, your organs are shutting down. In a persistent vegetative state, you are brain dead, but your brain stem keeps organs functioning. So what gets really difficult is when death is imminent and you can't communicate, and the doctors have determined we can't do anything because your organs started to shut down. We can't stop them from shutting down. There's nothing we can do. If they have you hooked up to breathing tubes and feeding tubes, if they keep you hooked up, you might live another week, another month. But if they disconnect you because your organs are shutting down, you're going to pass away quicker. And a lot of people don't want to prolong the act of dying. If you can be saved, great. But if you can't, then go ahead and disconnect me and let me just pass naturally. So that's the whole purpose of the living will, because you're putting in writing, this is what I want if this happens to me, so that although there's always guilt from the family in making that decision, you've told the family in writing, this is what I want you to do, which helps to lessen that guilt. The alternative to that is, and I've gone through it with a personal friend, he didn't have a living will, and he was in a car accident, was put into a medically induced coma. They had him on breathing tubes and feeding tubes, thought he was going to do fine. Turned out that his organs started to shut down. So his dad was the only person that could make the decision. And with a bunch of support from family and friends, and when I say a bunch, there were like 15 of us there, all telling him what the right thing to do was.
Right.
It was still an extremely difficult decision that he could make. If he would have had the living will in place, it would have been easier for him, because you're always second guessing. Is this what I should have done? Is this what my son or my mom or my dad would have wanted me to do? And by putting it in writing, you're saying, yes, this is what I want you to do. This isn't your choice. This is my choice. So the doctors have told you that death is imminent and that this is what I want you to do. So that's why the living will is so very important to have.
And I think the living will started right down the street at the Clearwater courthouse with the Terry Schiavo case.
Well, Terry Schiavo is one of the reasons why we have that persistent vegetative state piece in it.
Okay.
Because deciding whether or not someone's brain dead and what we should do with them, because your brain stem is the reason you keep breathing. You don't have to think, I need to take a breath. So your brain stem is doing all that for you. Well, if we leave you hooked up to breathing tubes and feeding tubes, your brain stem is going to keep your body functioning. But if there's no brain activity, then you are legally dead, and we take you off life support, and you're going to go ahead and pass away. And when we say take you off life support, people are afraid that, there's going to be a lot of suffering going on. No, they keep you medicated, so there's no suffering, and they just let nature take its course.
And I think the Schiavo case really had to do with her parents and her husband had a disagreement about what to do.
They couldn't decide
right.
who has the right to make the decision. So
and if there was a living will,
Terry would have been able to designate somebody to make that decision, and the decision would have been made by her, not by her husband, not by her parents. It would have been made by her.
In the living will.
In the living will.
I only wish they named it differently, because how many people get confused between the living will and the regular will, the formal will?
It is very confusing. So one of the things that I do in my office is I do a combination living will healthcare surrogate. So it's really your healthcare surrogate, but that living will is in it for you. So when you take it to the hospital, if you're going in for a procedure, you have everything with you. And that's one of the things people forget to do. Take your healthcare surrogate every time you go in for a procedure, because if something happens and they discover an additional procedure they need to do, they need to know who to contact.
Oh, that makes sense. That makes sense. I can imagine many people don't bring that with them. They have it at home, or they have it in a safe deposit box or something, but they don't bring it with them to the hospital.
So my mom's a great example of that.
Oh, okay.
So my mom went in for what should have been a very simple procedure. And while she was under the procedure, she was having gallstones removed, which they do thousands of those a day. They discovered some of the stones had moved and were blocking her liver, which is a second procedure. They knew who her kids were, and so they called each of her kids. And that's the thing, when you don't have a healthcare surrogate, all of your family, you're either your husband, or if you don't have a husband, because my dad was deceased, then your adult children are making that decision. And if one person decides, I don't really know if we should do that, the doctors aren't going to do it because they don't want to get sued. So they'll wake the patient up from anesthesia, get the authority from the patient to put them back under anesthesia. Fortunately, in our case, we remembered my mom had a healthcare surrogate. It was her friend who was a nurse. They called her friend, got the healthcare surrogate, kept her under, did both procedures, but it just took a little bit longer than it should have.
Wow. Well, I have 10 brothers and sisters, so I can't imagine if the doctor had to call all 11 of us to try to get
trying to get 11 people to agree to do something.
That'd be kind of a challenge.
Probably have difficulty deciding where to go for dinner, don't you?
That's exactly true. That's usually ends up 2 different places.
Exactly.
So, no, but yeah, so that's very helpful to know the importance of those documents. Now, estate planning also, I assume it includes creating a will or a trust.
So a will and a trust are very similar documents. They both dispose of your assets when you pass away.
Okay.
Your will is a document that is a public document, and when it disposes of your assets, it's an immediate distribution. So the difference between a will and a trust is a private document. The trust, you can put strings on things and say, okay, my son gets money when they're 25, when they're 30, when they're 35. They don't get all the money up front, where the will would dispose of the money up front.
Yeah, it's a one-time.
Exactly. And the other problem with the will is if you have minor children, minors in the state of Florida can't inherit $15,000 or more. If they do, the state of Florida steps in and puts in a guardianship. So now you have to pay the state of Florida, plus you have to pay for a guardianship, and you have to keep that money in control until that minor turns 18. And then they turn over the money, however much money is left, to that minor. So you can imagine what a minor would do, somebody who just turned 18 with $20,000, let alone 200, 300, or million plus.
Right.
It's going to be gone in a matter of weeks.
Right.
So by having a trust, you can put some strings on things and give some guidance.
When should a person either get a will or get a trust?
Well, again, as soon as you turn 18, you should at least have a will.
Okay.
You should have a trust once you start having assets to dispose of, because probate can be expensive. And every person who has a will or doesn't have a will, those assets go through probate. So there's basically 3 ways to dispose of assets. You can dispose of assets with beneficiary designations, and you can write on a beneficiary form, give my money to Steve when I pass away. That doesn't go through probate. That goes straight to Steve. You can have a joint account. And so you and I could have a joint account together. It doesn't matter who puts the money in. I pass away, you get the money. You pass away, I get the money. Doesn't matter what my will or my trust says, because that's just going to be controlled by the owners of the account. And then the third way is to go through probate. And probate is just the legal process of changing title from a deceased individual to a living individual. So that's a title on a bank account, title on a house, title on any other piece of property, even a title on a car. By having a trust, we can fund the trust with beneficiary designation, so that when we pass away, all the money goes into the trust has the strings, the trust disposes of the assets, and the trust avoids probate.
And that sounds very important, especially when it comes to estates that have a lot of assets.
So that's why I like probate so much.
Yeah.
So what people don't realize is Florida statute, although it is not a requirement, Florida statute is used as a guide, and the Florida statute says 3% of the first $1 million is a reasonable fee for both the personal representative of your estate. So in Florida, people are used to hearing the term executor because they like using it in movies and TVs. Well, when you use the term executor, that refers to a man, and an executrix refers to a woman. Florida said, we're not doing any of that. We're just going to call them a personal representative. So the personal representative and the attorney are each entitled to 3% of the first $1 million, 2.25% of the next $1 million, and then it drops down to 1.75 from there. So it can get really expensive for probate, which is why attorneys like it.
Right.
But if you're looking to really transfer and preserve the majority of your legacy, then you want to have a trust put in place with proper designations going to the trust.
That sounds good. Now, but what happens if there is no will or no trust and somebody dies?
So that's a fancy term called intestate. It's just another way to say you died without a will. You still have to go through probate. You're going to have to hire an attorney to do it. The Florida statutes, if it's a very small amount of money, and by very small, I mean $75,000 or less in assets, you can potentially do it yourself. However, every single time I've seen that, it gets messed up and they end up hiring an attorney after the fact to fix it.
I always use the analogy because when my clients ask me after a car accident, do I really need an attorney? I said, well, you don't need an attorney. I don't need somebody to fix my air conditioning at my house. I could try to do it myself, but then I'm eventually going to have to call the expert because I'm going to do something that's wrong.
Which is going to cost you more than.
Well, yeah, exactly. I did something that made it cost even more. So I can see why, although you can do the probate yourself, it's not wise.
And it's only the summaries that you could potentially do, but it's really best just to spend the money, hire an attorney, and let an attorney get it done for you. So summary administration can be done in maybe 90 days.
Okay.
Sometimes a little less. It depends on how quick the court can get things done. And last time I checked, Pinellas County Court's running about 4 weeks behind on processing documents.
Oh, okay.
Formal administration is for anything more than $75,000. And that process takes anywhere between 9 to 12 months, which is why it gets as expensive as it does.
And a lot of, I think it's a misconception in society is that they think, well, gosh, if I die without a will, then it all goes to the state.
And the state doesn't get any money. Unless nobody else is there to collect the money, and then it's transferred to the state for somebody else to collect it, hopefully one of your family members, but that family member is going to have to open up a probate in order to get access to the money.
Right. So I always try to tell them it doesn't go to the estate.
No, but the state does write those rules that say where it goes,
right.
And they write out how much it could potentially cost you in order to do it. So
right.
Somebody who dies intestate, the procedure that's written in Florida statute says everything to my spouse first. If there is no spouse, to kids and grandkids. If there are no kids and grandkids, it goes up to parents, then out to siblings and nieces and nephews, and it can go as high as grandparents and out to first,
and cousins,
second, third
and
cousins.
Everything too.
Yeah. We've got a probate right now that's out to I think there's first and second cousins once or twice removed. So it gets complicated.
Wow. So yes, you are listening to FLA Law. If you're just tuning in, thank you for tuning in. I am Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm in Tampa Bay. But I'm also here with Adam Rallman. He is, as you could hear, a well-educated estate planning attorney. We're going to talk about probate. We're going to also talk a little bit about business law too, because I know you do that as well. And so I think that's important to let the listeners know that as well. But if you all have a question, give us a call at 727-441-3000 while we're still live on the air, which we are for the next 32 minutes. So give us a call, again, 727-441-3000. So Adam, in your estate planning business and probate business, I hear a lot of time in my auto accident business that, I don't have to worry about probate because I have a will. And I tried to tell them how wrong that is. But again, I'm a personal injury attorney, so I usually defer to people like you who understand how wrong that really is. Can you tell our listeners, how that's such a misconception that you can avoid probate by having a will?
So the Florida statute actually says if you have a will, that will is supposed to be deposited with the clerk of court in the county where you live when you pass away. If there are any assets in the estate that don't have a beneficiary designation, that don't have a joint owner, the only way to transfer those assets, including your house, is to open up a probate and hire an attorney to get that done. So you're right. That is a major misconception. And I've had a lot of people come in 10 or 15 years after mom and dad have died, and they've been living in mom and dad's house the whole time. Wow. They never changed the title on the house. Now they're trying to sell it, and they go, I can't because I don't own it. No, you don't. We have to put it through probate, have the court recognize what's a homestead, and then the court will put in an order saying, yes, by the Florida Constitution, the homestead did transfer you, and now here's the order, which is your deed. You can now transfer that house.
Wow. So it could be all kinds of problems years and years later if you don't act upon it.
Somebody somewhere eventually is going to have to do probate for the estate.
Right. And because there's a will,
just because there's a will, you're going to have to do probate. So will or no will, the only way you can transfer your asset and not do probate is joint ownership or beneficiary designations or putting assets into the trust. Everything else has to go through probate.
That sounds good. And how long does probate usually take?
So if it's a summary administration where there are no creditors and maybe it's just a house, somewhere between 30 and 90 days, depending on how quickly we can get the paperwork done, how quickly you sign it, we get it filed, and how backed up the courts are in order to get it transferred. Everything else, which is formal administration, takes a minimum of 9 months, typically on average about 12 months, maybe a little bit more, depending on whether or not you have to file taxes in the following year.
Okay, wow. And I know we talked about that you filed the will where the person passed away, the county where the person passed away.
Yes.
Correct. What if the person owns property, let's say in Georgia? We were talking about going to Georgia before the show. What if somebody owns property up in Georgia, but their main residence is here in Pinellas County? Will the probate just be handled through Pinellas County?
I actually have two probates. We open up a probate in Pinellas County because that's where your home residency was. And then we have to turn around and open up a probate in Georgia as well. So the Florida probate has to stay open until the Georgia probate gets finished. And then we can close out Florida after that.
Wow. And if you're not licensed in Georgia to do that probate, you have to have a Georgia probate attorney handle that?
We go around and we find another attorney in whatever state you're in, because I am only licensed in the state of Florida. So we have to find another attorney in another state, let them do their probate process and transfer those assets there. So I can draft a trust and then we can go see an attorney in another state, have that asset get transferred over to the trust. And when you pass away, we can avoid probate in all the states. Or even if you did everything correctly in Florida and you forgot something in another state, especially when it's real property, then we're going to have to turn around and do a probate up there. Now, the bank accounts don't really matter where those are because those are personal assets,
Okay.
but the real property,
that
then we're going to
matters.
have to open up a probate in whatever state that is.
So my head's spinning because of all the things that could cause problems and could result in probate. Well, we hear all these commercials about how to avoid probate.
So
What advice would you give someone to how they could avoid probate? And how would they do that?
So the best way to avoid probate is to have a trust. Now, one of the mistakes that a lot of people that have a trust, well, the misconception of trust is I don't need a trust because I don't have that much money. The trust isn't about how much money you have. It's about whether or not you want to avoid probate. And another reason to have a trust is anytime you have minors, you absolutely want to have a trust. So maybe you're in your 60s, 70s, or even your 80s, and you're thinking that some of my money might eventually get to my grandkids, because if you and one of your children pass away at the same time, the money's going to go to the grandkids. And if the grandkids are under 18, we're back to having a guardianship in the state of Florida. So we need a trust in order to avoid the guardianship. So the trust avoids the guardianship. The trust is going to avoid probate. Even for a guardianship where nobody's making any arguments about the fact that the money is going to the kids and who should control the money, the guardianship for the children, to put that in place, you're going to pay for the probate and somewhere between $2,000 to $7,000 for the guardianship for the kids. And then it's just more expensive and more expensive and more expensive.
Yeah, and then the guardianship's only till they're 18.
It's only till they're 18 and we're going to turn over the money. So we end up with what I referred to in my financial planning career as red Porsche syndrome.
Okay.
Where you hand over a large sum of money to an 18-year-old who has no concept of what money really is.
Right.
They think they don't ever have to work. They think they can go buy all these things in a few days, the money's gone.
Wow. Yeah, so that's why trust is so important. You know, whether you have millions of dollars of assets or whether or not you just want to take time to plan. I mean, that's what estate planning really is, right?
Exactly. So the trust, one of the other problems, or not problems, one of the mistakes that people make when they're married, in the state of Florida, we have what's called tenants by the entireties, which is a protection only for husband and wife. So I say husband and wife. That's husband and wife, could be same sex, husband and husband, wife and wife, just traditionally saying husband and wife. And so with a married couple, tenants by the entireties, and you know this from car injuries, if you try to sue the car owner and it's just a spouse, a single spouse, and the other spouse is not on the title, so maybe the husband was driving the car, the husband's on the title, you can only sue the husband. You're going to get money from the insurance company, but you're not going to be able to go after the husband's asset, or I'm sorry, the wife's assets. You can only get the husband's assets if the husband was the owner of the car. If you own assets joint, tenants by the entireties, that protects those other assets, and you can only get individual assets. So with a trust, the trust itself has no asset protection. So I have married couples continue to own their assets as tenants by the entireties, and we put beneficiary designations, pay on death, transfer on death, or an actual beneficiary designation on an asset. So when both spouses pass away, their trust gets funded, all the assets get distributed from the trust.
Oh, that makes sense. And reminded me that I had a case where my client was on the back of a golf cart, and the golf cart driver negligently drove it to cause her to fall off. And many attorneys told her, sorry, you can't do anything because all his assets are tied up in a trust. And so I said, well, I am not a probate attorney, but I do a radio show that I get to listen to probate attorneys talk to me and educate me as well. And so I knew that that's not the case. Just because all his assets are tied up in a trust doesn't protect him from any negligence claims.
No, so if it's your trust, if you're the grantor or the settlor, the person who created the trust, then you and the trust are one and the same. Your trust specifically says when you pass away, your trust is supposed to pay your debts. So if your trust has to pay your debts when you pass away, then your trust can pay the debts when you're alive as well. So even with a married couple, we know we have tenants by the entireties protection. The trust, you may not get that protection. There's been some case law out there that makes that questionable. And because you can, if it's just your individual trust and you are an individual who doesn't have any asset protection by just being a single person, then we can go into the trust and we can take those assets out of it. Now, there is a different portion of a trust if you're the beneficiary, not the settlor. If you're just a beneficiary of a trust, there is some protection in that. And that's where the misconception comes from, because there's what's called the spendthrift protection. So you owe me money and you're the beneficiary of the trust. And I know there's millions in that trust, but you're only getting paid thousands per year. I can't get the money from you until it's actually paid to you, because that's when it becomes your money. So that's what the spendthrift provision prevents. It prevents me from going through you into your trust to get money that you're not getting yet. And I've got to wait for it to pay out.
Oh, that makes sense. And I can see why people would get that misconception, thinking, okay, Joe Smith is getting money from Grandpa's trust, but if he's only getting $4,000 a year, then you can only go after Joe Smith for $4,000 a year, even though he's going to get $4,000 a year for 50 years.
Exactly. So every year you can get part of that $4,000 that comes out from him.
And what's that called? Spendthrift?
It's a spendthrift provision that prevents your creditors from going through you to get your trust, and you have to wait for the money to be paid out. So one of the other reasons to tie money up in a trust is to only provide for income. So if you have a child that, and I say child, child could be any age, but you've got a child that doesn't necessarily handle money well or has had some problems in the past, you can tie that money up for a long period of time for their entire life if you wanted to.
And I heard that that's one of the benefits of a trust over a will, is that if you have somebody that has special needs or is just careless with their money, the trust is able to provide protection to the family, preserve the family legacy, but the will wouldn't be able to.
The will wouldn't do that. So if you had like a special needs child, then, and that special needs child were to inherit money from your estate, they would lose whatever government benefits they're currently receiving. Sure. So we have a special needs trust that's able to prevent that from happening. So your child can continue to receive the benefits and the trust can supplement any shortfalls that you may have.
Yeah, and we see that in our practice because we sometimes have clients who get injured in a car accident and that are on government assistance because of a special need. But if we make a recovery for them and we just do it normally, they could lose those benefits. And so that's why we always have to reach out to somebody like you that sets up that special needs trust so they can still recover for the accident without suffering the consequences of losing their benefits.
Exactly. So the supplemental, it adds to whatever they're getting so they don't get kicked off the benefits.
That's perfect. That's perfect. So we've been talking for, about 40 minutes now about estates and probate and trust and estate planning. But in addition to all those areas of law, you also help people in their business law issues.
So
can you explain what you do for the business owners?
So we do a couple things for the business owners. Number one, we do corporate minutes. We can also set up corporations. So a lot of times we go out, we see somebody who already has a business. Well, that business is part of your estate. And that's one of the things, the stock certificates or the membership certificates is part of your estate. And people don't think about that. So you could have a trust and you could put all your other assets going to the trust. But if your stock certificates or membership certificates are just in your name, when you pass away, we have to probate the value of that business in order to transfer the value of the business over to your wife or your kids or whoever it's going to. So we tie in our estate planning and the asset protection to include the business. We put beneficiary designations on the stock certificates or the membership certificates so that when you pass away, they transfer into your trust so that the business is in the trust. We also do buy-sell agreements. So that's where 2 partners or 3 partners own a business. You don't want to be in business with your partner's spouse. Your spouse doesn't know anything about the business you're in. So you do a buy-sell agreement that specifically says, if you or I pass away, what's going to happen to the stock? Well, it's going to go to the spouse, but I'm going to give the spouse money from the business to buy the stock back from them. So they get the value. I get to continue to run my business and not have to worry about my partner's spouse meddling in my business through she doesn't know anything.
So I can see how your experience as a financial planner, but also your experience in the estate planning and probate and trust are so important and so beneficial actually to your business law clients as well.
Well, everything that I do ties in together and it's all preserving that legacy. So when you have the business, that business is part of your legacy and we want to make sure that we can preserve and transfer that. We also do business sales. So if you wanted to sell it to your kids, which happens a lot, your kids are in the business and you're not quite ready to be done, but you want your kids to take over, we can work on transferring that business over to the kids. We can sell it to a third party. Now, we don't find the buyers. We just work on the paperwork to get that to happen. I've got 4 business sales that I'm working on right now. We tie that in with the estate planning. We make sure we protect those assets too by doing the tenants by the entireties. And so it's an overall package for everything we're doing.
There are so many ways that you can preserve the legacy that if you're not in that business, you don't appreciate. And more importantly, you don't know what you don't know.
Exactly.
And that could end up hurting you really badly.
So it's funny, when I got my insurance license, every time we'd ask the instructor a question, his answer was, well, it depends. And so
that's a lawyer answer, that's for sure.
I find myself saying, when people ask me questions, well, that depends quite often.
Yes, we do that all the time. In fact, I had a client right before this show that I had to say that probably about 3 or 4 times because it's just uncertain. And that's in the car accident arena.
Exactly.
So what types of businesses can be formed? I know there's sole proprietor and...
So there's really only 2 types of businesses you set up. You either set up an LLC or you set up an Inc. Now, from that, there are different taxing portions of that. So if you're a single member LLC, then it's typically a flow through where all the money the LLC makes flows through to your personal income taxes. When you have a partner, it turns into a partnership. So you may say, oh, I have a partnership. You do, but that's the taxing designation. You have an LLC that is taxed as a partnership. Another way a business is taxed, which is the way most small businesses are taxed. So the plumbers and the air conditioning people, most companies that you would think of are taxed as S corps.
Okay.
So a lot of times I will ask people, what type of company do you have? And they'll go, well, I have an S corp. I go, well, that's how it's taxed. But do you have an LLC or do you have an Inc.? And so the difference between a limited liability company, an LLC, and an Inc., which is just a full corporation, the LLC has membership certificates and an Inc. has stock certificates, they operate very closely, and then you just pick the type of taxing designation you're going to be. Most people setting up a C Corp, which you don't see a lot of, would set up an Inc. Then LLC gives you the majority of asset protection that you can have for the corporation by setting up an LLC and not an Inc. So the vast majority of companies we set up are going to be LLCs, and then they're either going to be single member partnerships or they're going to be S corporations.
Okay. Wow. And knowing what you know about estate planning and preservation of legacy and also of assets, what is there one type of business that's better for the business owner than another, or it depends?
It really depends. So if you're going to be a single member, it would be best to set up the LLC, realizing that the single member, it doesn't have as much protection by statute as what a partnership would be. So even you and your wife, if you wanted to open up a corporation where you're going to own the vast majority of it, you're going to be doing all the work. If we add your wife to the company, you become a partnership or a multi-member LLC. And a multi-member LLC has a one level up in protection, so that I can't pierce the corporate veil. I can only get what's called a charging lien. And a charging lien would allow me to take your place. And when money is distributed out for my judgment, I get paid the money. You control the company. And if there's no money coming out of the company, I don't get paid anything.
Okay.
As soon as my judgment gets paid, you're back to getting the money out of the company. With a single member, there was one bad apple case in 2010 called Olmsted that said that you can pierce the corporate veil and go after personal assets. So we try to avoid that at all costs, but we do a lot of single members as well. We just have to advise them that those things can happen.
Okay. And what protection do they have if they're a corporation?
So in an LLC, you have two sides of protection. Protection from the outside coming in. So you get sued personally. I can't come in and take assets from the company just because you did something. That's where the charging lien comes into place. And then on the business side, I can't come out of the corporation and go after personal assets. So you put $100,000 into a business, into an LLC, your liability is limited to the $100,000 that you put in. If your business fails, if you get sued, they're going to get what the business owns. And if the business only owns that $100,000, that's where it goes. So a lot of times when people own rental properties, that's where we're setting up a lot of corporations. So I take your rental property, if you left it in your individual name and something were to happen on the property, a dog bite, then your insurance may or may not cover it. And if the insurance doesn't cover it and it's in your individual name, I'm going after personal assets. But if we take that house and we put that house in an LLC, the most the attorney's going to get from suing you is the insurance money and maybe the house itself.
And that's the problem, that some people have 4 or 5 different houses that they use for rental property. And so if they have it only set up as themselves, as individual, then they're on the hook for the value of all 5 or 6 properties.
Exactly. So
even though dog bite happened only in one area.
So what we would do is potentially set up 4 or 5 different companies. It depends on what you want to risk. So if you're willing to risk 2 properties or 3 properties, throw them all into one LLC, but don't own them in your individual name. So I do, when I go out and see people, that's one of the things that I'm doing a lot of times, is setting up a corporation just to put a piece of property that's a rental property in that corporation.
To protect those assets,
to preserve their assets. So if it's a husband and wife, we set up the corporation as a partnership. It flows through there's no taxing difference on the corporation side when you set up a partnership than it was when you and your wife owned it together, because it's all flowing through onto your personal tax return. The taxing difference comes from an S corp because of how that company is taxed. And if you're not producing some sort of widgets, you don't want an S corp. You're either going to be a partnership or you're going to be a flow-through entity, single member.
Oh, that makes sense. We do have about 10 minutes left, so you are listening to FLA Law on the radio. This is Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the proud sponsors of FLA Law on the radio. But also I have Adam Rallman here as well. As you could hear, that he's able to talk to you about and answer your questions about estate planning, wills, trusts, probate, and even business law. So if you have a question, give us a call now at 727-441-3000 or hop on to the firm's Facebook page where we are live now. And that page is Perenich, Caulfield, Avril Noyes Injury Lawyers. And you can type in your question right there and we'll be able to answer your question as well. But Adam, you've been so informative. I appreciate it so much. Now, every successful person, whether it's in person or in life, has a mission statement. And I read your mission statement on your website, and your mission says to ensure the client's wishes are honored, their families protected, and their legacies preserved for generations to come.
Yes.
How did you come up with that mission statement?
Well, part of that comes from when I was doing the estate planning or the financial planning and what I was trying to do on the financial planning. But really, when you're coming in and sitting down with me, the estate planning side is just making sure your wishes are getting followed the way you want them to do, and setting up things to preserve as much of your estate as we can preserve to get to the next generation, whether that generation is 2 or 3 generations down the line or just going straight to your kids. And it doesn't matter how much that is, we want to make sure we can transfer as much as possible, which is why I do like probate. But if you're looking to preserve your assets, you don't really want to go through probate.
And that's at least 6% being gone.
If you have a personal representative who decides to take the fee, yes. So if you hire your friend to be the personal representative and the friend is going to transfer the assets to the kids, the attorney's going to take 3%, the friend's going to take 3%, and your kids are going to get 6% less.
And if the kids are under 18, then you have the guardianship cost as well.
If you don't have the trust, you're going to have the cost of the guardianship.
Estimated cost of a trust versus estimated cost of a probate, assuming that there's a guardianship that has to be involved as well.
Well, just for a will, power of attorney, healthcare surrogate, living will, and for the trust, I charge $3,500 at the moment. Your probate is going to cost significantly more than that. If you have
$100,000 in assets, that's $6,000 right there.
Just if you have a house and that's the only asset, I'm charging $5,000 for probate plus cost. The reason I'm doing that, a lot of times we're having to go in and have a hearing on things because somebody will file a claim. And although your house is a protected asset, that's one thing I'll just touch on really quickly. There's 2 types of homestead. They're very similar, but there's the homestead that everybody's familiar with the taxes, keeping your taxes low. So we stop increasing your taxes as much as the county wants to. I think they're limited to 3% a year. The other part of the homestead is the constitutional homestead that says when you die, well, it says when you're alive, your house is protected from all creditors. There's only 3 entities that can take your house. A mechanic's lien, somebody who works on the property that you decide not to pay, the mortgage company because you borrowed their money to buy the property, and taxing authority. So the county taxes, property taxes, federal taxes.
Uncle Sam can always take your
Uncle
house.
Sam can take the house, but nobody else can touch your house. So you could have $100,000 in credit card debt. They can't put a lien on your house. If that house travels along bloodlines, then that house will remain a protected asset and that house will transfer free and clear of all other creditor claims. If that house goes to your friend Steve, then the house can be potentially sold to settle those other debts.
Okay.
So with what we're looking to do, even if you have just a house, it's homestead, it's protected from creditors. If I turn around and open up a probate, that's not going to stop a creditor from filing a claim because they do have a legitimate reason to get paid. They just won't necessarily get paid from the house.
That makes sense. So it's so important that's part of the planning, and I didn't appreciate that. Yeah, I know the homestead you talk about that reduces your taxes, and I also knew that it protects the person, the homeowner while they're alive, from any claims made against them. But I didn't appreciate that it can continue when you pass away as long as it's still in the family.
So if it follows along bloodlines, we can have it declared homestead, which is one of the reasons why the probate's open. We have it declared homestead by the court, which tells all creditors, look, that's off limits. You can't touch that. It goes directly to the kids. Kids can turn around and sell it. You can actually open up a probate, sell the property, transfer the money to the kids and have the house after it's sold declared homestead, which means the proceeds from the sale are also protected.
Wow. But a way to avoid all that
is to have the trust.
Is the trust. There's all kinds of steps that I've heard about how you can do that if you have to go through the probate.
Exactly.
But there's only one step.
There's only one way to avoid it. Again, I really like probate. So, if you're listening and you just want to go through probate, please come in and see me. But if you want to avoid probate, I can help you do that as well.
Yeah. So we do have about 4 more minutes now. What I always like to ask is if you had an opportunity to tell our listeners 5 things that they should know about your practice, what 5 helpful tips would you give them?
That's a good question. Number one, I'm going to listen to you and take every matter. You get to talk to me. You're not just calling in and talking to a paralegal. I'm sitting down and talking to you. I'm walking you through all these things, and I'm always here to answer questions.
And I think it's also important, and I know you do this, you talk to the client. If it's a family member involved that may come with the client, you keep that family member out of that conversation, right?
So I'll sit and talk in general. These are things, how they work. This is what those documents are. This is why you want those documents. But once it comes down to what the client themselves wants to have done, I take everybody else out of the room. It's me and the client. We sit down and go over what your wishes are so that I make sure we're getting done what you want done. When you come back to sign, it's the same way. If your son or daughter or somebody brings you in, we can talk in general, we can answer questions, but I'm going to have them leave the room so we can discuss what you want in case you want changes in those documents as well.
Perfect. What other tip or advice or things you want them to know?
I'm always there to answer questions. So I'm not just a one-time stop in, get the estate planning done and never see me again. I'm always there to answer questions. I'm there to help you as your life changes. And for every life change, you should come back and sit down with me to go over what those changes are.
That's what I was going to ask you. How often should they see you and when should they see you?
About every 3 to 5 years.
Okay.
The laws change, your life changes. The other thing that would bring you to come in is if some other life event happens, birth and death, come in and see me. Let's talk about it. Does it have any impact on your estate plan?
Perfect. And it looks like we have about 2 more minutes. But so I want to make sure that our listeners do get to listen to how they can get in touch with you when you're not on FLA Law on the radio. How can they get in touch with you? You
can find me at preservationlawfirm.com. My telephone number is 727-250-0432. That's 727-250-0432. My email address is adam@preservationlawfirm.com. I do have a Facebook page, and when you go to the webpage, you can reach me by text. In addition to the telephone number, the 250-0432, you can also text me on that number as well.
That's perfect. And if you didn't have a way to write all that down, you can always reach out to us at Perenich, Caulfield, Avril Noyes, and we'll be happy to share Adam's contact information as well.
I really appreciate you inviting me out tonight.
Adam, it was great. Yeah. I learned something new every time, so I appreciate you coming. Thank you for taking the time. Try to take some break from starting your new practice. But listeners, thank you very much for listening to FLA Law on the radio. I am Matthew Noyes, and I always love to end the show with to drive safely and to watch out for those who don't. Take care.